Welcome back to USA State. If you have seen headlines lately about green cards, work permits, and the future of legal immigration in the United States, you are probably feeling a mix of confusion and concern. And honestly, that makes complete sense. The topic of what will happen to green cards and employment authorization documents, or EADs, in 2026 has become one of the most searched and most misunderstood immigration questions right now. Today we are going to break it all down, separate fact from fear, and give you a clear picture of what is actually changing, what is rumor, and what you need to watch out for this year. If you are interested in this topic and liking this video, please stay tuned until the end of the video. If you are liking this video, please hit the bell button, subscribe and like it so that you may get updates straight to your smartphone. Now let's get into the video. Let's start with the question that is on everybody's mind. Is the United States actually going to end work permits? The short answer is no, not entirely. But the longer answer is much more complicated. What is happening in 2026 is a significant tightening of who qualifies for an employment authorization document, how long those permits last, and under what circumstances they can be renewed. The administration has made it very clear that reducing what it calls discretionary parole-based work authorization is a top priority. But here is what you need to know. The EAD program itself, tied to lawful permanent residence applications and certain visa categories, is not going away. What is changing is the eligibility scope and the processing landscape around it. In a recent development, United States Citizenship and Immigration Services, or USCIS, has been under mounting pressure to restrict automatic EAD renewals for certain categories of applicants. For years, individuals with pending adjustment of status cases, meaning those waiting for their green card while already inside the United States, could apply for an EAD using Form Y-765 and receive a work permit tied to their pending case. That pathway still exists in 2026, but reports suggest that processing times have stretched significantly, and in some cases, automatic extensions of up to 540 days that were put in place in recent years are now under review. So who exactly is affected? The people most directly impacted fall into a few key groups. First, there are those on humanitarian parole or under temporary protected status, known as TPS. The administration has moved aggressively to wind down or challenge both of those programs, and individuals relying on parole-based EADs have been receiving notices that their authorization is expiring or will not be renewed. Second, there are people with pending I-485 applications, which is the form used to adjust status to lawful permanent resident from inside the United States. These individuals can still file for an EAD, but the backlog at USCIS means many are waiting far longer than expected for their cards to arrive. Third, and this is a group that often gets overlooked, there are spouses of H-1B visa holders, known as H-4 visa holders, who were granted EAD eligibility in 2015. That program has faced repeated legal and political challenges, and in 2026, it remains a target for further restriction. Beyond work permits, the green card process itself is undergoing some real turbulence. The priority date system, which controls when immigrant visa applicants from specific countries can move forward in the queue, has continued to show severe backlogs for applicants from countries like India and China in the employment-based categories, particularly EB2 and EB3. For family-based categories, the F2A preference category, which covers spouses and children of lawful permanent residents, has seen fluctuations that have caught many families off guard. In practical terms, this means that even if you filed your I-130, which is the petition to establish a qualifying relationship with a U.S. citizen or green card holder, years ago, your priority date may still not be current, and you could be waiting an additional 14 to 16 months or even longer just to move to the next step of the process. Here is what this translates to for people currently in the system. If you are waiting on a green card through a family sponsor, the processing pipeline at the National Visa Center and at U.S. consulates abroad has remained slower than pre-pandemic levels. Consular processing, which affects applicants who apply through their home country rather than adjusting status inside the United States, has been further stressed by staffing challenges and increased scrutiny of applications. Officers are looking more carefully at documentation tied to public charge grounds, meaning they want to see strong financial support through the Form 1864 Affidavit of Support, and in some cases are requesting supplemental evidence of ties to the home country or financial stability. Now, the real question is, what does this mean for people who are already living and working in the United States on an EAD tied to a pending case? Immigration experts note that the single most important thing you can do right now is track your case status on the USCIS website and file renewals as early as possible. USCIS allows applicants to file for an EAD renewal up to 180 days before the current card expires, given that processing times for I-765 applications have reportedly stretched to 6 months or longer at some service centers. Filing at the earliest opportunity is no longer just good advice. It is essential. If your EAD expires before your renewal is approved, you could be facing a gap in work authorization that affects your employer compliance and your income. Advocacy groups warn that the current environment of policy uncertainty is creating what some call a chilling effect, where legal immigrants are afraid to travel internationally, afraid to change employers, or afraid to apply for benefits they are fully entitled to receive. Legal analysts suggest that while the administration can tighten eligibility and enforcement, it cannot unilaterally eliminate congressionally authorized immigration pathways without going through the formal rulemaking process, which involves public comment periods and potential court challenges. Several proposed rules that would have significantly restricted EAD categories were challenged in federal court in late 2025, and those cases continue to shape what USCIS can and cannot do in 2026. As a green card applicant, or EAD holder, this situation might feel overwhelming, but there are concrete steps you can take. Keep all your documents organized, including your I-94 arrival record, your visa stamps, any approval notices, and receipts for pending applications. If you have an attorney, keep them updated on any changes to your employment or personal situation. If you do not have an attorney, consider consulting one, particularly if your case involves any complexity such as a prior visa overstay, a prior denial, or a change in employer. And stay connected to reliable sources of immigration news because the situation is changing quickly. To put this in perspective, the 2026 immigration landscape is one where legal pathways remain open but are significantly more difficult to navigate. The administration is using every administrative tool available to slow the flow of certain categories of immigrants, but the green card program as a whole, the employment-based preference system, and family-based immigration continue to function. The fear that the U.S. is about to shut down all work permits overnight is not supported by current law or current actions. What is true is that the environment is stricter, wait times are longer, and scrutiny is higher than it has been in recent years. That means staying informed, staying proactive, and making sure your paperwork is always current is more important than ever before. It remains to be seen how courts will respond to ongoing challenges and how any future legislative changes in Congress might reshape the system. But for now, the best protection you have is knowledge and preparation. That's all we have for this bulletin. The USA State Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the USA State Channel for more U.S. immigration update videos.